Afternoon, I'm your host, Brian Buckmire. Now, we've got two cases we're looking at today. One is live and one we're recapping. First, as to the Boyd case, if you were with us this morning with Jesse Weber, you saw the DNA expert on the stand testifying as to some of their findings. Now, not a lot of forensic evidence as it stands for defendant Eric Boyd, but they did say that they found a little bit of DNA on the gun holster. Direct examination was done this morning, a bit of a break for lunch. We're going to catch back up with them in the afternoon for cross-examination of that expert. But until then, we want to recap the Hollywood Ripper case out of California. Now, the case had come to an end yesterday. They have today off. And on Monday, the jury's going to get the case and begin deliberating. But before that, we want to give you a recap of some of the closing arguments that were heard in that case. So I rarely say this, but I always find this prosecutor's cross-examination and also his closing arguments to be spectacular. I think he's really connecting the dots here. Now, I'm joined here with Norman Williams in studio and Latonia Hines via Skype. Latonia, first to you, how are you doing today?
Fine, how are you, Brian?
Great. So in this summation, I'm picking up on two very big things, circumstantial evidence as well as consciousness of guilt. How big are those two, factors or elements as it comes up with this case?
Oh, it's very big, and especially for jurors, because here's what you're trying to do. This is a common sense case. So you're trying to basically dispute anything that the defense could possibly say is a reason for doubt. And he's showing the location. He's going piece by piece of everything that they've heard and making sure that they remember it and why you must believe that the defendant is the person who is the perpetrator who did this.
And so, Norman, for you, whenever I explained circumstantial evidence to someone, the easiest way for me to explain it to people is footsteps in the snow. Right. You might not see the person who walked in it, but you see the footsteps and you're saying, hey, obviously someone walked here, otherwise they wouldn't be here. But there's obviously ways to get around that. How is this prosecution going to be able to lay down that, hey, these are actually someone's footsteps and not just someone, they're Gardrullo's?
Well, I think circumstantial evidence plus the consciousness of guilt is what allows the jurors to hang their hat on the guilt of the defendant. I mean, it's kind of hard to get around consciousness of guilt. And although jurors aren't required to take that evidence as being real, they can. And if it makes sense and if it comports with common sense, defense has a problem.
Okay. Now, I know sometimes when it comes to consciousness of guilt, it can be a dual-edged sword because one action can actually have dual meanings. And I know a lot of prosecutors like to think, hey, if you, for example, run, you must be guilty. I give you the example of if I hear a gun go off and they arrest me for the gun possession and say, hey, Brian, you ran because you obviously possessed the gun. And I'm like, no, I heard a gun go off. Right. I ran. Right, exactly. So when that has a dual meaning sometimes, I guess how does let's go to the defense attorney side because I like that side better. How does the defense attorney say, hey, there are more than one ways you can interpret this. Well, don't just focus here. Right, the argument is there's an innocent interpretation of the actions of the defendant, and that's a doubt. That's good enough for reasonable doubt. Yeah. Let's see if the prosecution can kind of tie this up a little bit better or maybe drive it all the way home, but look at more of the closing argument. So it seems that the connection between these blue booties is what's really driving it home. Norman, we were talking about circumstantial evidence. Is it less circumstantial now that there's some sort of connection with the booties?
Possibly not. Possibly not. I mean, if the blue booties can be connected to him, he has a problem. If the blue booties can be connected to the crime scene, he has a problem.
Yeah. Now, Latonia, I mean, I'm assuming that these booties don't have his initial on it. His mom didn't write his name on it. So what's to say that this isn't just a booty that's sold in Walmart that anyone can get?
Right, and so that's the reason why you have to try to put all of the things together. And it's kind of a hard case on some levels for the prosecution because there's no DNA. There's none of what we would call hallmarks to this case. And so that's why these blue booties become a very, very important thing. And the more that you can be able to show that they are something that is so very common for him to always have, the fact that you connect it to the scene, and then with him, it makes it a little bit of a stronger circumstantial case.
Now, Latonia, I know oftentimes I'm telling my family, I'm telling my clients, this isn't TV. It's not what you might see every day. I know we're on TV now, but with this case, a prosecutor's arguing, well, he's a criminal mastermind, and of course he knew how to hide the evidence. I mean, is he that sophisticated of an individual that we're supposed to believe that he just no DNA? Or is it really the fact that just like his DNA is not there because he wasn't there?
So that's the hard part for the prosecution. And so that's why you have to go into this mindset of this person. And that's why you have to explore. And the prosecution's got to make it very clear that this is something he thinks about these types of things. He's not like you or I in the fact that we are normal people. He has a criminal mindset. And so he's thought of these things. He thought that he was smarter than any of the authorities could possibly be. But we all know that those people who think they're so smart usually make a mistake or something happens. And that's what the prosecution's trying to rely on and saying that he tried to be better than the best criminal, but all criminals make mistakes, and that he did make mistakes.
So, Norman, I see you shaking your head in agreement, and I would agree as well, but let me play devil's advocate for a minute. I mean, our viewers watch Law and Crime however many times they watch. I'm hoping they watch them 5 days a week and twice on Sundays, right?
Right.
But they're getting to see this, and they're getting a knowledge of how these cases work. I mean, that argument might have worked 10, 20 years ago, but now the average person watches CSI, watches Law and Crime, so maybe they're sophisticated enough to do this. So maybe it's not that this is such a peculiar bit of information, but everyone kind of knows how to do this.
Right. I think the advantage that we have on the defense side is that jurors are expecting to see DNA. And they think that what they see on CSI and on the crime shows is what's reality as opposed to what's made interesting for them to watch. And without there being any DNA to tie this guy to the booties, it does get a little difficult. But on the other hand, yes, this guy has a criminal mind, but really it's not about having a criminal mind, it's about being bright or not, right? Thinking your way through a bad situation is no different than thinking your way through a good situation. And all of those things show his preparation. All of those things show premeditation. They're things that are bad for the defense, but hopefully the defense can drive a truck through the fact that there's no DNA.
Let's see. Well, we're going to take another look at the prosecutor's closing argument as to how he's trying to tie this whole case together. Let's take a look. Very interesting from the defense attorney, laying out basically the burden of proof. Again, reaffirming with the jury that they have to prove this beyond a reasonable doubt. Latonia, is this the type of case where it's just a question of burden rather than the DA being able to truly prove their case?
So I think it's kind of a little bit complicated. Obviously, we don't have DNA here, so there's not that to prove the case. But this is where you have to still be about the common sense and about whether or not how these things all happen together. Is it that just a coincidence that these things happen, or that like you have the blue booty, or are these just coincidences that also link you to the defendant, or is it more probable than not that this is truly what happened? And I'm not quite sure about the abiding certainty. I mean, it's beyond a reasonable doubt. It's not all doubt. So I'm not in my opinion, the closing argument so far by the defense has not made me feel emboldened to think that the defendant is not guilty.
Yeah, and I know, and Norman, I would tend to agree with Latonia. And I know that they're supposed to be all the same, but there's not guilty, there's innocent, and the prosecution not reaching their burden. I mean, and it ends up being all the same thing,
right?
But it seems like, I mean, factually or just between regular people, it's not, though.
Right. You know how it is with us defense attorneys. When we start to talk burden, sometimes we don't have other arguments, and that we have to remind the jurors that, look, it might seem like things look this way, but if the prosecution didn't prove it, they didn't sustain their burden. So we like to use that word burden because we think about that heavy hill that the prosecutors have to climb in order to get a conviction. And we just like to remind jurors of that.
Yeah, and as a defense attorney, you've got to kind of build that hill to make it insurmountable for the prosecution. Let's see if the defense attorney succeeded in that in his closing arguments. So again, as we were kind of hinting at, this is a very heavy burden argument. Now, Norman, the fear that I typically have from this argument is, I think of the three of us, we all are learned legal professionals, but I bet you we all have different interpretations of proof beyond a reasonable doubt. So how do you get a jury full of people who have never studied the law to all agree upon it to get a unanimous decision for your client?
Well, I think that's the moment where you have to be conscious that speaking to other lawyers doesn't really get you to the finish line in terms of what do you need to present to a jury. Like, there's a big difference between what we think about as legal professionals and what the average lay person thinks about. And you really have to speak to the lay person. But sometimes when you know that there's a lawyer or two on the jury, you signal to them what exactly the thought process should be. So, you know, you have to be careful. I mean, jurors are diverse and jurors are just not lawyers, really.
Yeah.
And they're more likely to believe what they see on television than what they're hearing in the courtroom. I can't think of how many times I've had a juror say to me, well, you didn't put on a case. And another juror will look at them and go, stupid, he doesn't have a burden. You weren't listening to the judge, were you? Oh, right. Because they're not thinking about the law. They're thinking about how they feel about stuff personally in the world.
And Latonia, in the same vein, how do you bring a jury to the concept of beyond reasonable doubt when they're not too familiar with it, and that's kind of all you have as a defense attorney?
So here's the thing, and always having to remember that the judge is also going to go over what beyond reasonable doubt means as well when they're doing the charging conference with the jury. But what I basically make them understand it's as a prosecutor, you're saying it's not beyond all doubt. And then if you are the defense attorney, then if your mind is unsettled, if you have any doubt as with regard to this happening, then you've got to, err on the side of not guilty. I got a really great tip one time from the legendary Johnny Cochran, and for the times when I was a defense attorney, which is, here's what you've got to remember. There's so much information that's gone on throughout a trial with a jury. And when you're talking about doubt, you need to give them something in your closing argument that when they go back there and they are deliberating, they remember that. And that makes them think that there's doubt. We all know, if the glove doesn't fit, you must acquit. Having some type of thing that they can remember that goes back to them when they go back in that jury room, that they go over that over and over again. So that's one of those things that you can do as a defense attorney. The hard part here for this case is that you don't have a likable defendant. You have, in addition to this, for the prosecution's sake, even though you don't have the DNA, you could believe that this is the person who did. There's enough circumstantial evidence to make you believe that he is the person behind this. And so it makes it it's not a cut and dry case, which is, most cases aren't cut and dry, but at the same time, it's not as, I don't want to say simple, but some of the cases that we have seen where you do have the DNA evidence, other things there, this requires a lot of thinking and making sure that you're making the dots connect and make the connections. If you're the prosecution, you've got to make sure that that happens. And if you're the defense, you've got to show that those things never did happen.
Yeah, it's going to be very interesting. We're going to continue with the Cardullo case and the closing arguments from the defense attorney after this break. So there you have both defense attorneys giving their input as to the closing arguments. Now, during the break, we were talking about how the closing arguments ties in with the entirety of the case. And Latonia, you brought up that this kind of all hangs on jury selection. It all depends on who those people are in the box hearing these arguments. And how does that play out?
Well, because I've always said that jury selection, like that, your case is won or lost in jury selection. Because you've got to make sure, because I always think of myself, whether or not I am the defense attorney or the prosecutor, I am the director and I am trying to get a certain story out to the jury. I'm trying to get them to believe my version of things. And so you've got to get jurors on there that are like-minded to what your story is. And whether if you're the prosecution, that this is the defendant who committed the crime, if you're the defense attorney, that your client's not guilty, or that the state has not met its burden. And so you've got to be very careful about making sure that you've asked the right questions during voir dire so that you get the right people on. And just so that people out there understand about jury selection as well, depending on the state and how it works there, you have this opportunity to ask questions, and sometimes the judge will give questionnaires out to the jury pool. You can review those, and then you'll have a certain number of strikes to, strike somebody that you definitely don't want because you think that definitely is against your client or against what you think the state's case would be. And then sometimes you get this meeting in the middle. So sometimes the jury that's selected is not your perfect jury, but the hope is that you've done the best that you can in the selection process and in asking questions to get a jury that is going to be enough that you can be malleable for purposes of your point.
Yeah, and Norman, we were talking during the break a little bit about SHOP, about how our different techniques of voir dire. I gave you the example that my professor at Belmont gave of the cat and the bird inside the box, but you cut a hole large enough for the bird to fly out, and then you ask the jury what happened to the bird. Now, it's reasonable that the cat ate the bird, but it's also reasonable that the bird flew out. And so in jury selection, when you're trying to get, I call it the Belmont method, if you're trying to get people to buy into your own beliefs, and you get those juries, it makes the lifting and summation that much easier.
No, that is true. I mean, there's so much that goes into jury selection. I mean, sometimes you just have to be conscious of the culture of your county that you're trying to case in, because the county next to you, the jury pool, has different leanings. I mean, there's so many things that you have to do when you're reading the tea leaves, as they say. You know, it's not a perfect science, but it's something that you have to employ. Like, sometimes it doesn't matter who the jury is, depending on what the charge is. Yeah. There's some things that everybody feels sympathetic towards, and there's other things that everyone's offended by. Yeah. So, you know, you have to be conscious of who you are as a person, how you deliver the message, how you're perceived by strangers. Like, there's a lot that goes into picking a jury. And sometimes you get it right, sometimes you don't. And I remember how many times throughout the years of my career that the person that I thought was going to be against my client was actually my biggest ally. And I was completely wrong about my stereotypical feelings about the individual.
Yeah. Let's continue as the defense attorney is closing, start to have alternate suspects and actually draws in Ashton Kutcher in their theory. So here you have the defense attorney switching gears a little, switching away from that professorial, they haven't met their burden, this is the standard by which they need to reach, and now driving to the concept of innocence. He's giving alternative facts, he's giving reasons why his client, Michael Gargiulo, is innocent. Is this a more powerful version of a closing argument now?
Yeah, I mean, I think one of the things that's interesting is there's no such thing as innocence in that courtroom, right? It's either guilt or not guilt. But speaking about innocence is what the layperson really can relate to. And that's really what they want to wrap their brain around. Is this guy innocent?
Yeah, and Latonia, same concept. As he's switching now to say, hey, my guy's on the stand here, but what about Tom here? What about Dick there? What about Harry there? And by the way, even Ashton supports my theory as well. Is this not only strengthening his claim of not guilty, but also maybe muddling up the prosecution's case?
Yeah, so I will say at this point he is doing a good job because, like you said, giving some other alternative ideas of how this could happen, what else is a possibility. And the moment you give other possibilities, and like Norman says, possible reasonable possibilities, then you start building in doubt. And that's all that the defense needs to do is get one person to believe their theory, and you've got the reasonable doubt needed for a not guilty plea. I mean, a not guilty sentence.
Yeah, we're going to continue following this case and more after this break.